111-299 Shannon Bogus v. State of Kansas.
May it please the court, Crystal Dalkey on behalf of the petitioner Shannon Bogus in this case. And I would like to please request 4 minutes for rebuttal.
4 minutes is granted.
And just a brief recitation of the facts. Mr. Bogus was convicted of first-degree murder as well as, I believe, 5 other crimes after waiving his right to a jury trial and agreeing to proceed with a bench trial on stipulated facts. At sentencing, Mr. Bogus filed a pro se motion to dismiss counsel, I believe is what it was titled. He stated that there was a conflict of interest and as well as made a couple of claims that trial counsel was ineffective. The district court had a hearing on that and denied his claims. Those were addressed on direct appeal and denied as well by this court. He filed the instant 60-1507 motion and raised another claim of ineffective assistance of trial counsel, among others, specifically that he was deceived by trial counsel and did not understand what stipulated facts meant, as well as was not apprised of the entire stipulation he was agreeing to at the time he waived his right to a jury trial. The district court denied relief on his 60-1507 motion. Mr. Bogus appealed, and the Court of Appeals found that his claims were barred by the doctrine of res judicata and went ahead and addressed the merits, I believe, on his claim of ineffective assistance of counsel and found that he had not met the Strickland standards. Mr. Bogus filed a petition for review, and that's where we are today.
And can we just point of clarification? In the initial appeal, I recall that the ineffective assistance of counsel or the motion to dismiss counsel, there essentially were 2 claims. One was that there was a conflict of interest based upon a kind of a distant relationship between counsel and a potential witness in the case that was never called. That came to the court's attention. And then that there was no closing argument on the trial based on stipulated facts. Those are the 2, I think it was limited to those 2 questions.
I believe you're correct. I think there might have been a claim that trial counsel was ineffective because they didn't put on a defense as well. But those were essentially,
and the trial court had a hearing. This is, again, in the initial trial and sentencing. Trial court heard evidence or heard statements of based upon that motion and denied the motion, proceeded to sentencing, and then we affirmed all of that.
That's correct.
And now there are some additional claims regarding the ineffective assistance of counsel.
That's correct.
But was that a motion for new trial based on ineffective assistance of counsel? My recollection was that he was seeking to replace counsel.
Right.
That is my understanding as well.
And didn't we analyze it based on a denial of substitute counsel, which is a whole different paradigm than an ineffective assistance of counsel under Strickland, isn't it?
Yes.
Where there's justifiable dissatisfaction. Did we ever make any determination on the direct appeal under Strickland for any reason?
I do not see that.
It's not mentioned in the opinion.
No, I do not see that in the decision. I see that you discussed the justifiable dissatisfaction standard.
The relief sought in the 2, the reason it's important, of course, the relief sought in the 2 is completely different.
Right.
Ineffective assistance would get a reversal. You'd be seeking a reversal, right?
That is correct.
As opposed to a ruling that you were denied a right to substitute counsel.
That is correct. I think that brings us to an interesting point. in preparing for this argument, I reviewed all of the cases kind of where this court has analyzed a motion for a new trial based on claims of ineffective assistance of counsel, as well as a motion for new counsel or to dismiss counsel for substitute counsel. And there's kind of two different standards that have applied, whether or not there was a conflict. They've kind of separated one group to was there a motion for new counsel, and then apply the justifiable dissatisfaction standard. And then also, was there a motion for a new trial based on claims of ineffective assistance of counsel, and have applied more of a Strickland or Mickens standard to determine the prejudice element of that. I guess going back a little bit, because I'm getting ahead of myself, but going back to Mr. Bogus's claim currently raised, that trial counsel was ineffective because they deceived him and did not fully explain what it meant to proceed on a trial of stipulated facts, including did not go over the entire stipulation agreement with him. The Court of Appeals found that this claim was barred by res judicata, that, well, Mr. Bogus raised other claims of dissatisfaction with trial counsel, and he could have raised this one in front of the trial court. Under this court's decisions in Rowland versus State and Grossman versus State, res judicata has typically not been a bar to claims of ineffective assistance of counsel. They generally are not reviewed on direct appeal unless there's, for instance, a Van Cleve hearing or some other type of extensive evidentiary hearing where there's been sufficient facts that this court can go ahead and review claims of ineffective assistance of counsel for the first time on direct appeal. Both Rowland versus State and Grossman versus State distinguished claims that might involve the same issue with a claim that trial counsel was ineffective that involved that issue, and said these are not barred just because they were involved the same claim or the same issue that we reviewed on direct appeal, when there hasn't been a full extensive evidentiary hearing on the matter. So it's Mr. Bogus's position that his claims that trial counsel deceived him, did not go over what stipulated facts he was agreeing to, as well as explain to him what stipulated facts meant, a bench trial on that, was not raised and addressed below and should not be barred by the doctrine of res judicata.
Now, the Court of Appeals also addressed the merits, though.
That
so
is-
you really have alternative holdings.
That is correct. We also disagree that Mr. Bogus did not meet the standard to warrant an evidentiary hearing. No evidentiary hearing was granted at below in the district court level, and at the get-go, Mr. Bogus needs to present, raise a claim of ineffective assistance of counsel that's more than just a conclusory assertion, and there needs to be evidence in the record to support his claim that maybe trial counsel was indeed ineffective. Here, Mr. Bogus stated that he was deceived by trial counsel and he did not understand what a trial on stipulated facts meant, nor did he go over the entire agreement with trial counsel before he agreed to waive his jury trial.
Sorry, go ahead.
Did he sign the agreement, though? Wasn't that in the transcript?
He did sign the agreement, and I actually found this morning, and I believe it's very important. If you look at the order denying, the district court's order in this case denying Mr. Bogus's 60-1507 motion, there's two, in the transcript from the trial judge's, what he said at the sentencing hearing, and also what he said at the jury trial waiver hearing. He references two different documents. He says there's a 3-page agreement which Mr. Bogus had signed. He said it's a 3-page document.
Signed by both counsel and the defendant, as I recall.
Yes, signed by all the parties, and including Mr. Bogus. And the judge also talks about a packet of information that it had received from the state, which included an amended affidavit and other documents. And the state talked about that packet as this is what our evidence is that we're presenting. And cited in the district court order, it notes that this stipulation of bench trial packet was 65 pages. So we're talking about 2 different documents. And what Mr. Bogus signed was that 3-page agreement. So there is evidence to support, especially if we're talking about 30 minutes, an hour tops, right before his jury trial is supposed to start, that trial counsel didn't go through a 65-page packet of materials with him, and he actually had a chance to review all that evidence, understand it, and knowingly waive his right to a jury trial and agree that I'm going forward with a bench trial on this 65-page packet of information.
But a person can waive a jury trial without being aware of every jot and tittle of evidence the prosecution intends to present, can't they? Can't he or she?
Yes, he can
You
waive
have
his
the
right to
right
a jury
explained to you.
trial, but I think, he's not claiming,
Isn't he saying?
he's not claiming necessarily that
Excuse me.
I want a jury trial again. He's claiming that I didn't know what the state was going to use to convict me when I agreed to go forward in this manner. And I should have known.
That's really, literally speaking, pretty true of everyone who waives. I mean, they don't ever know for sure what's going to happen in terms of how
Right.
the evidence is going to come.
Right. I think, in this case, there's factual support for Mr. Bogus's claims in that it was 30 minutes, an hour tops before his jury trial was supposed to start.
And his claim is that he didn't know what it meant to stipulate
Right.
to fact.
Right. He
That
thought
his attorney told him, we're stipulating to the evidence that will be presented by the state, rather than we're stipulating that evidence is true.
right.
But what about the judge's question? When he says, and you understand that the stipulated fact will take the place of actual live testimony, that it'll be in the form of documentation presented to me. That documentation are the only facts I will receive, the only that I will consider, and the only facts from which I will make my judgment. You understand that? Having been told that, what was the confusion with your client?
And of course I'm speaking for him here, but I believe the confusion was he thought just kind of that 3-page document or what he had signed and what he had been told during those 30 minutes was what he was believing the state was going to present against him. Instead, there was, all of this other material that he didn't have a chance to review. He thought his trial attorneys were actually going to present some type of defense on his behalf, do something more than just agree to being found guilty because of this packet of information.
Wasn't the purpose of the stipulated trial in the first place was preservation of his suppression question?
I believe
we
that
went to great extent to
right.
reach it, but wasn't that the purpose of this procedure? Rather than a plea was maybe rather than a plea, but at least that was the underlying motivation to enter into the stipulated facts was to preserve this issue.
That's correct. It was made known that they were doing this because they wanted to preserve the appellate rights.
And in fact, wasn't there an initial statement made that Mr. Bogus didn't want to put the family through a trial?
I believe he said that as, he stated that it was all happening very fast. He was kind of panicked. I believe he basically said on the record that he wanted to go back and lay down, just wanted to get it over with, which again, I understand that was the mindset at the time he agreed to do all of this, but he wasn't.
No, that's a significant fact.
And again, this is kind of, to answer your question, I don't know, because there wasn't an evidentiary hearing on this. I don't know what he knew. I don't know what trial counsel told him. All I know is from what he asserted in his pleadings and was raised at the district court. Did trial counsel say anything? Did they tell, had he seen all of this information the weeks before trial? These are questions that I can't answer because it's not in the record, which is the reason for having an evidentiary hearing on this.
I thought the nature of his complaint was that his attorney explained to him the nature of stipulated facts was simply, we're agreeing that the state will present this evidence, rather than a stipulation is, I stipulate that that's true, which is different than, I didn't know all the facts that were going to be submitted.
Right.
And if it is that complaint, that I didn't know the nature of stipulated facts was not merely the presentation of evidence by the state, what's the practical difference? I stipulate the state's going to present all this evidence to you, and that's what our trial's going to be about, just that evidence. Or I stipulate that this evidence is true. Is there any practical difference for your client?
Well,
You understand what I'm asking you?
I do understand what you're saying, and I think it's very easy for us to understand as lawyers, and being in the judicial system, and we know what stipulated facts means, and we know what happens when you have a bench trial on stipulated facts. But here, Mr. Bogus knew that, okay, this is the state's evidence. Instead of them telling the district court through a hearing, they're just going to give him all the material and we're stipulating that this is the state's evidence. What Mr. Bogus did not understand was that by stipulating this is the state's evidence, he wasn't then going to get to present evidence to counter the state's evidence, and that would be the end of it.
Other than the judge told him he wouldn't.
I guess the judge told him that, but we're looking at more what trial counsel did before they got to that
That goes to
point, and whether
prejudice.
he knowingly agreed to get there in the first place.
But even if there is some failure on the part of trial counsel, that can effectively be cured by this colloquy between the judge and the defendant, i.e., to Justice Byers' point, there's no prejudice.
That was one thing that, the Court of Appeals in its decision said, well, hey, he could have said, no, wait, I don't understand. No, wait, I need to talk to trial counsel some more. When you get to the point where the district court's asking you these kind of routine questions and they're like, no, sir, yes, judge, no, sir, yes, ma'am, no, judge, they're doing what trial counsel told them to do. They're not sitting here thinking, oh, I really don't understand this, but if I say something now, trial counsel is going to be like, no, we talked about it. They're doing what trial counsel told them to do. And what the focus is what happened before he even got to that point. And that's where Mr. Bogus is saying, trial counsel told me to do, A, B, and C, and I didn't understand that A, B, and C was essentially me agreeing to be found guilty to all 6 crimes as charged. I didn't understand that A, B, and C meant I can't put on a defense. I didn't understand that A, B, and C meant that the judge was going to review 65 pages that I didn't have a chance to review and use that to find me guilty.
All right, counsel, thank you. We'll see you in rebuttal.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I think as your honors pointed out, the Court of Appeals in this case did make essentially alternative findings. The panel found that both of his issues were barred by res judicata, and then also did address the merits of each of the claims. Our position, not surprisingly, is that the Court of Appeals was correct, that both of the issues that he's attempting to raise in this appeal are barred by res judicata.
Where in the original Bogus opinion did it deal with ineffective assistance of counsel under a Strickland analysis, and how could it without having a Van Cleve hearing?
The opinion itself, the direct appeal opinion itself did not cite the Strickland standard. But the question is whether the defendant has raised the issue before. He raised in his pre-sentencing motion, he raised this issue.
And that was a motion for new trial?
It was a motion to dismiss counsel. And in the written motion.
And you would agree that a motion for substitute counsel is a whole different paradigm than a motion for new trial based on ineffective assistance of counsel?
I wouldn't agree with that as a blanket statement. No, I think you have to look at the actual facts of what happened in the particular case and how it was argued. And here,
obviously, every motion for substitute counsel involves displeasure with the performance of your counsel, or you wouldn't be asking for it. But that just because you've argued your attorney's no good or deficient performance doesn't transform that into a ineffective assistance of counsel issue.
So you're saying that arguing that your counsel was ineffective does not turn it into an ineffective assistance of counsel?
Not when the relief sought is substitute counsel, rather than a new trial based on the denial of a Sixth Amendment right to effective assistance of counsel.
Then by that standard, you're creating a situation by simply repackaging the same issue, a defendant could continue to bring the same underlying issue again and again by labeling it the first time as a motion for new counsel, then as ineffective.
We do that all the time.
What's that?
We do that all the time. We allow that all the time. In essence, let me explain why I say that, and so you can explain to me why it's different here. We have direct appeals, and defendants raise substantive issues, instruction error, for example. And a little while later, after the decision comes down adverse to them, we get a 1507. The counsel was ineffective for failing to challenge or anticipate, etc. I mean, so we have, I understand your point that the basic substance is similar, and in fact the same. But it's a different legal claim with different elements that need to be demonstrated for relief. And the relief sought is different.
Well, and certainly in that particular example that you give, I know that I have personally written many briefs where our argument is that you should not do that, that is inappropriate use of a 1507 to try and backdoor a claim of trial error by attaching an argument of ineffective assistance of counsel.
And they are usually unsuccessful if in fact that's the case. But if they are different legal claims. They have different legal theories, different elements, different relief sought. Isn't that correct?
They're not identical, certainly. There is a distinction to some extent, but the basic argument, I think, is what we need to look at. And here, while the pre-sentencing motion was captioned as a motion to dismiss counsel, at the hearing on that, which immediately preceded sentencing, that's where he did branch out, and as opposed to the written motion, which just was making this argument about a conflict because there was this relation with a potential witness. At that hearing, he did, and I think our Court of Appeals opinion pointed out that he did, at the hearing on that motion, he did branch out into ineffective assistance arguments.
And what was the test that was to be applied at the end of that evidentiary hearing by the presiding judge?
Well, it would have been, to the extent that it was, if he had stuck strictly to the written motion, it would have been whether he had shown justifiable dissatisfaction, which would have warranted the appointment of new counsel.
And so they would not have litigated a Strickland test on effectiveness of counsel at the trial court.
I don't recall them doing it in those specific terms. Now,
And if that wasn't litigated, how is it res judicata?
because as the Court of Appeals panel noted, and as this court has noted, res judicata does not just apply to issues that are actually raised. It also applies to issues that could have been raised but were not.
But what you're arguing is the facts were presented. That the facts presented were that my counsel was ineffective, but the issue was I want substitute counsel because there's justifiable dissatisfaction. The fact that you have the same facts presented on two different issues does not amount to res judicata of the second issue.
I guess we'll have to agree to disagree on that. I think that when this defendant is standing in front of the court pre-sentencing and is given every opportunity in the world to discuss why he believes that he should be allowed to, whether it's have a new attorney appointed or to back out of his waiver and his stipulation, and essentially to tell the court anything that he wants to say about why his waiver was not voluntary, that is an issue that very clearly could have been raised.
On your understanding of res judicata, I mean that's so broad, isn't it, as to entirely eliminate the category of ineffective assistance claims in 1507 motions. I mean, every defendant has that opportunity, right? In the way you just articulated it.
Well, I guess I would draw a distinction between situations where a defendant does not assert that right at all and it's never brought to the court's attention, in a situation like this where the defendant does bring an ineffective assistance claim and then essentially litigates that or the underlying issue on direct appeal, and then just wants to come back and add a new twist to it by now saying, well, now I want to throw in my claim specifically that I was deceived. The defendant points out both in his brief and today at argument that the general rule is that ineffective assistance claims will not be reviewed for the first time on direct appeal. That's correct, but it's the general rule because there's an exception. And that exception is when there is a sufficient record below. And I would argue that what happened here, even though they might not have specifically articulated Strickland or mentioned that test, that what happened here was sufficient, that res judicata should be triggered. He stood before the court before sentencing and argued that his attorneys were ineffective. He should not now be able to come back and say, my attorneys were ineffective because, oh, guess what? There's another reason that I simply chose not to get into at that hearing. And I think it's especially important in a case like this. The argument that he's attempting to raise here is saying that I was deceived. That's something that clearly was within his own knowledge at the time of the sentencing hearing. This isn't a situation where he's trying to come back years after the fact and raise a complicated legal issue where we could look with sympathy and say, well, we can't expect a pro se defendant to know the ins and outs of the legal consequences. He's saying, my attorney deceived me. He was in the position better than anybody to raise that argument at the time of sentencing.
And why would he know that he had been deceived? If the deception is, my attorney told me that stipulated fact simply means that you stipulate the state will present some evidence. Versus you will stipulate that you admit that those facts are true. Why would he know that, particularly when he was filing his motion for substitute counsel?
Well, even if he didn't know it when he filed the motion, he certainly knew it when he stood in front of the court, and there was this colloquy, this lengthy colloquy, where the court did point that out. And I guess that's where it somewhat merges into the discussion on the merits that the Court of Appeals had, is that even if you want to indulge and say that there's, for the sake of argument, there's some showing that counsel did not properly advise him, or that there was this deception. That's where the district court's actions in going over this colloquy and explaining the stipulation to the defendant would cure any potential prejudice. The ultimate question is whether the stipulation and the waiver of the jury trial was knowing and voluntary. So even if somehow counsel was deficient.
That's the ultimate question, but the initial question is, should he have had a hearing? Was summary denial appropriate? Should he have had a hearing at which he called his attorney and was able to ask him under oath, did you tell me that this is the nature of a stipulated fact?
And summary denial is appropriate if the records and files of the case conclusively show that he can't meet either prong, whether it's the prejudice or the deficient performance prong. And we can look at the record here, the cold record, and see what the district court told him at the time that he stipulated, and we can conclusively say that he cannot meet the prejudice prong. Because again, even if you want to speculate and pretend that his attorney didn't, the district court did. And so therefore, there's no need to have a hearing to come back and find out and say, well, all right, his attorney did or did not tell him this, but ultimately the decision is the same because we know what the district court did. And that would have cleared up any potential confusion that the defendant had based on what counsel did or did not say. We have a written stipulation that he signed, and we have a lengthy colloquy with the district court. Those two things would essentially be rendered meaningless if a defendant could just get up and say, well, despite what I told you then, despite what my signature affirmed, I didn't really mean that, so I should be able to essentially...
What's your opinion as to this separate packet of information? Does that have any bearing given the written stipulation?
I don't think it does. In light of that written stipulation and in light of the colloquy, and as your honors pointed out, I don't know that there's any requirement that a defendant, in order to stipulate validly, has to know every single piece of evidence that the state had at their disposal and know the exact script that the state would have followed if the case did in fact proceed to a jury trial. I think that the stipulation that he did sign, along with what he said in court in his discussion with the district court judge, was more than enough here to show that this was a knowing and voluntary decision.
Certainly that's true when someone accepts certain types of pleas, but this was a stipulation of facts. How does one stipulate to facts without knowing what the facts are specifically?
Well, I think to that point, I think Justice Johnson made the correct observation that what the defendant essentially argued, his argument wasn't so much that I didn't know what the facts were. It was I knew what the facts were. I knew what the facts that the state was going to prove were. I just didn't realize that I was agreeing that those were actually true. And so even the defendant himself seems to be shifting the argument here when he's saying that he didn't know what the facts actually were, which I think, again, is an indication that he's simply trying to throw things out and hope that something sticks in an effort to gain relief.
Excuse me, I didn't. Yeah, at one point he apparently did contend that he thought there would be some defense presented. So is it valid that he didn't have an opportunity to know from that packet that there was nothing in there that would have supported the defense that he would be asserting?
I'm not in a position to speak very intelligently about the packet because I don't think that specific argument has been made by the defense until today, and so I certainly didn't review the record to look carefully at the two different packets. What I can say, though, would just be to reiterate what I said earlier, is that what happened at that hearing, that discussion that he had with the court, gave him a full opportunity to clarify any confusion that he might have walked into the courtroom with that day. When the district judge engaged with him in that discussion, to the extent that he truly felt like he was somehow hoodwinked by counsel and didn't know what these stipulations were, that was his opportunity. And the fact that he never made that assertion at that point, I think, is telling. I think that would lead a reasonable person to believe that that was not actually something that he was confused about, that he did understand to the extent required by law what he needed to understand in order to be able to knowingly and voluntarily waive his jury trial and enter the stipulation.
It sounds like you're wanting us to be skeptical of the evidence, but is that our role?
Am I
here?
that obvious?
Is that the role that should be accomplished through a hearing with the trial judge making the factual findings and then us reviewing those?
Well, certainly, if there is a hearing, the district court can make credibility findings on matters like that, and then this court would be obligated essentially to adhere to those credibility findings. But I don't think that it's necessary. That doesn't mean that a hearing is required every time a defendant raises something. I think that obviously the 1507 case law is clear on that the court first should make a review of the records, filings, and motions and determine whether summary denial is appropriate. And again, the case law does very clearly say that even it's okay. Traditionally, we start with the performance prong, and then we make our way to the prejudice prong. But the case law very clearly says you can do that the other way. You can skip performance, and you can go right to the prejudice. And if you can determine conclusively that there was no prejudice suffered as a result of counsel's actions, then summary denial is appropriate.
When we do that, we essentially assume the truth of all the allegations.
Yeah, essentially, yes. And certainly I don't for 1 second obviously believe that his allegations are true, but for purposes of that analysis, you can work that way and conclude that even if true, he's not entitled to relief because it is a two-part test and you have to meet both prongs. So our position is that this is the type of case that can be disposed of simply by looking at the record, that he has not raised a sufficient issue that necessitated a hearing, and that whether it's based on res judicata or whether it's based on the decision that the Court of Appeals made on the merits, that no further relief is necessary, that the Court of Appeals did get the correct result by denying relief and affirming the district court. I see that I'm past my time. If there are no other questions, we would respectfully request that the district court be affirmed.
Thank you, counsel. Reserve 4 minutes for rebuttal.
I wanted to touch on 2 points. First, while it's fresh in my mind, I respectfully disagree with counsel. I believe that Mr. Bogus can show prejudice in that, had he known all of this information at the time before he waived his right to a jury trial, he would not have waived that right and proceeded on a bench trial on stipulated facts. Assuming, if we do just skip to the prejudice factor and assume that all of this is true, Mr. Bogus was deceived into waiving his right to a jury trial. He did not know what the stipulated facts were, and he would have wanted a jury trial. He did say that in his petition that he filed, that he would not have waived his right to a jury trial and essentially agreed to being found guilty as charged. So I would argue that that's the prejudice that this court should look at and consider under its review whether Strickland has been met. Going back also to the issue of, could have Mr. Bogus raised this at sentencing in front of the trial judge? No, he couldn't. With the way that the way that the hearing was set up, he did not have new counsel appointed to represent him and argue on his behalf in front of the sentencing judge, in front of, I believe it was Judge Pullman in this case. Mr. Bogus had, if he could have raised claims that trial counsel was ineffective, then he had no one representing him at a critical stage that would present evidence on his behalf when the state was represented. So trying to equate what happened at his sentencing hearing with trial counsel on his motion to dismiss and substitute new counsel. That's not a Van Cleve hearing. That wasn't a ineffective assistance of counsel hearing. It just was not set up with all the players necessary to allow a factual basis and a complete evidentiary hearing, and all the factual requirements that this court could use to determine, oh, we have all the facts.
But we have allowed that at that particular stage or in that time frame in the district court, if under the guise of a motion for new trial based on ineffective assistance of counsel. In other words, a Van Cleve hearing before it comes up here. And we've allowed that issue to be raised other than in 1507.
I agree. I'm making this more as in response to opposing counsel's statement that Mr. Bogus could have or should have raised this.
But your point is that he couldn't file a motion for new trial based on ineffective assistance of counsel without the assistance of new counsels. What your point is?
To the point that the Court of Appeals and, to bar him under the doctrine of res judicata, then yes, that's my argument. I mean, petitioners file 60-1507 motions and make arguments all the time without the benefit of counsel appointed to represent them. But they're not barred then under res judicata as saying, well, they could have raised this below in a post-trial motion. And so I think we're getting a little kind of, because they could have said it, it's not the same as having a full Van Cleve hearing or some other type of evidentiary hearing where new counsel has been appointed or retained to represent them, and old counsel where they have the claims of ineffective assistance against have the ability to freely testify and not advocate against their former client or argue their own ineffectiveness. I think that's kind of the distinction between other cases where it may have come up on a direct appeal and this court has gone ahead and addressed it. I see that I'm... Oh, do you
I
have...
was just going to ask if we had any further questions of counsel, or are you going to the home stretch?
I would just request that this court find that Mr. Bogus's claims are not barred by the doctrine of res judicata, and that he has made a substantial showing that an evidentiary hearing on his ineffective assistance of counsel claims was warranted, and to reverse the decisions of both the District Court and Court of Appeals. Thank you.
Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.